Okay, Tony, you ready? Let's go on the record on DC 234781, Peoples v. Jesus Daniel Gutierrez Rodriguez et al. Council, make your appearances.
Paul Hers for plaintiff Anna Peoples, Your Honor.
And Jill Hers for the plaintiff.
John Fowler for defendants Gutierrez and Gallardo.
All right, you may proceed.
Yes, Your Honor, thank you. This lawsuit concerns a motor vehicle accident that occurred on December 5th of 2021. Plaintiff filed their original petition April 12th, 2023. They asserted claims of negligence against defendant Gutierrez and a negligent entrustment claim against Jesus Gallardo.
There seems to be a pretty big difference. I've read the briefing on this, on whether or not the driver was actually licensed, and that you said he was licensed. They say he wasn't licensed. Well, it looked like from the testimony that he testified he was not licensed. So I'm just trying to get a feel for what's going on with that.
Sure. And I don't think the license issue is the key issue here.
Okay.
But Mr. Gutierrez did have a Venezuelan license. Okay, he had a Venezuela driver's license. He's an immigrant. He can't get a Texas driver's license. So, but he,
that's an interesting question.
And I'm not sure if the statute requires a Texas license. It just says must have a driver's license.
Have there been any cases that have been? I don't know. I've never.
I haven't done the research on that issue, Judge, but I think the real issue here is ownership of the vehicle. Obviously, we got a negligent entrustment.
What are the standards for getting licensed to be a driver in Venezuela versus the United States? I don't really know. Does anyone know that?
I'm not sure, Judge. I suspect they have requirements for a written test and a road test, much like the state of Texas or any other state or country.
Do we know that? Do we have any evidence of that? Is there anything in the record that indicates that?
No, there's no evidence of that. No evidence of the standards in Venezuela.
Is there anything, I know like if an American goes to Mexico and gets in an accident that they're allowed to drive, or is somebody from Venezuela allowed to drive in the United States? It's kind of the same way. I just don't know.
Well, obviously, we give full faith and credit to driver's licenses from other states. I'm not sure about other countries.
Okay. So I know you seem to be kind of abandoning that argument. You're really focusing more on the ownership issue.
Exactly, Judge. I feel like that's the key issue on the negligent entrustment claim.
According to the title, who owned the vehicle?
Well, the title is held by Elias Guevara.
Is that your client?
But we do not know. I do not represent Guevara.
Okay.
Okay, so he had a relationship with Gutierrez. He rented the car to Gutierrez on a weekly basis. It was Gallardo that actually insured the vehicle, but Gallardo didn't have ownership of the vehicle. He didn't have any possession of the vehicle. He had no right of control.
He's not the
over
driver,
the vehicle.
Right? Gallardo's not the driver.
Gallardo's not the driver. Gutierrez
was
was
the one
driver.
who allowed the driver to drive the vehicle.
Right, and we had sworn testimony by Gutierrez regarding the ownership of the vehicle by Guevara, Elias Guevara, who's not a party to the suit at this point. I had requested plaintiff's counsel dismiss Gallardo because I don't feel like the negligent entrustment claim is viable since he didn't own the vehicle. I mean, that's one of the key elements of proving negligent entrustment is ownership, control of the vehicle. He had neither. And we have testimony of the actual owner of the vehicle.
Is there a written contract that existed on the lease?
No, it was kind of a handshake, friendly agreement. I need a car.
So we don't know.
I'll rent it from you for a week by week.
So we don't really know if it's a lease or he was purchasing the vehicle, other than just what they say.
Yeah, I'm not aware of any lease agreement or any contract in that regard. I think it was probably an oral contract.
Even one in Spanish, maybe?
I think it was more of an oral agreement, Your Honor.
Okay.
But like I said, I think the key issue, not necessarily with the driver's license, is an issue, But I think the more important issue is ownership of the vehicle as far as the negligent entrustment claim. And, you know, the elements of negligent entrustment require ownership of the vehicle. As well as, you know, the owner allowed an unlicensed, incompetent, or reckless driver.
So you agree there's at least a fact issue on that element?
As far as the license issue, I
Yeah.
think there may be a fact issue.
Okay.
He did have a driver's license, so I think we could argue he was licensed. It wasn't a Texas driver's license, it was a Venezuela
But
driver's.
there's
license.
at least a fact issue as to that issue for summary judgment purposes. You may argue it at trial, but summary judgment.
Well, I think the key issue for purposes of this summary judgment motion is ownership
Okay.
on the negligent entrustment.
All right. What's y'all's
Fairly clear.
argument? What is y'all's argument on the ownership?
Yes, Your Honor. As noted in our response, there's a little bit of confusion as to ownership because the vehicle this is a 2000 model year Toyota Camry. It had a paper plate. After some research, we believe it to be fraudulent. It mentions that it was sold by AutoNation and it has the VIN on it. It's in our Exhibit D and I can hand it to the court if I may approach.
No, why don't you show it on the screen?
Yes, Your Honor.
Go ahead.
And then a little more. It's not pivotal whether this is a legitimate paper plate or not, Your Honor, but just incidentally, the issue is the 8 that appears in the VIN before the 96420 and the AutoNation. That's our Exhibit D, and we did VIN searches, which I'm going to omit, and that VIN did not show up, but we did a title search on the version of the VIN that contains a 3 instead of an 8. And that shows, this is our Exhibit C. That shows that the last title owner of the vehicle was Root Insurance right here. I'm sorry, Root Insurance. The contended title owner, Elias Guevara, as defendants contend, never appears in the chain of title as best as we can find. As we mentioned in our response, this is a private database because there is no truly public database of titles, but it's compiled from public data. Our best theory is that this ended up on an insurance impound lot and through legitimate or otherwise means it found its way to defendant Gallardo, and then it was leased or entrusted or.
He says the title is is with another person. Where do you get that from? I guess?
In their production, and I'm trying to find which exhibit that is. Our Exhibit B is an excerpt from their production, Your Honor. And this is their amended, which was very recently. Trying to figure out number 8, copies of all driver's licenses not applicable. Number 9.
We can't see it on the
Oh,
screen.
I'm sorry. These are kind of the 2 pivotal RFPs. Number 8, driver's licenses not applicable. Number 9, a copy of the title not in possession. We've never seen the title either formally or informally in the duration of this.
So you said earlier that the title was in somebody else's name, but you don't have a copy of the title?
We do not have a copy of the title, Judge, and
Why don't you have a copy of the title?
well, my client wouldn't have a copy. He's not the owner of the vehicle. Neither Gutierrez nor Gallardo would have a copy. They're not, neither one of them are owners of the vehicle.
Okay.
It
You are
it
able to
appears
search.
to be that Elias Guevara purchased this vehicle at an auction and never transferred the title and never put title in his own name. That's my assumption, but we don't have a copy of the title.
Your Honor, I think as far as title ownership, Elias Guevara, who defendants contend is the owner, and Gallardo, who we contend is the owner, are on equal footing. They're not the legal title holders, but we've created at least a fact issue on ownership sufficient to survive summary judgment because Gallardo had to have an insurable interest in the vehicle to be the policyholder on it.
Does either of you have any case law on this?
Yes, Your Honor. It's in our response. I don't know if I'm in a position to fully recite it, but it talks about, again, the insurable interest more at length. It's our footnote 25 on page 8 goes into it somewhat. I think the main case recently is Jones versus Texas Pacific Indemnity Company, which cites a much older case, Smith versus Eagle Star. Essentially, an insurable interest isn't necessarily ownership. It wouldn't be enough to, win the day conclusively on ownership, but it does create a fact issue because one explanation of an insurable interest is ownership.
And who's, for this vehicle, who's the insurance under?
It's under Gallardo and,
That's your client?
It's under Gallardo.
and that's it.
We
They,
are defending Mr. Gallardo, and the whole insurable interest issue, I mean, that's a separate coverage issue. There's no issue that's been raised.
So
as
he
coverage.
quotes the Lowry case saying that that's sufficient to defeat a summary judgment. How do you distinguish Lowry?
I don't think it's certainly, it can be proof of, or can be evidence of ownership, but it's not conclusive.
But what does Lowry say?
I'm not sure what Lowry says, Judge. I would need to refer to that case.
Do you have, anybody have a copy of the Lowry case?
I do not have a copy, Your Honor. I've just cited it for the proposition that it is sufficient evidence of ownership to create a fact.
I mean, that seems to be kind of the crux of this whole thing, is that if the insurance is in his name, Lowry, according to that footnote, says that that's sufficient to defeat summary judgment.
And I think, Your Honor, Mr. Fowler correctly said it is not conclusive, but we're not required to prove it as a matter of law at this stage.
That's right. It's not conclusive evidence. It can be some evidence of ownership,
Isn't that what they need to show at this point?
but we know who the actual owner is.
Do
They
we?
could dismiss Gallardo and pursue Guevara
But
because
Guevara-
he's the owner of the vehicle.
But
He's
he's
the
not
one
the-
who has control. and
he's not
possession
the,
of
but
vehicle.
he's not the title owner. Either of them are the title owner. Right? I mean, you can't show any evidence Guevara is the owner either. You don't have a title. And you can't find it online that he's the title owner either, can you?
That's true.
All right. Good argument, guys. Summary judgment is denied. You have a proposed order?
Your Honor, if I may intercede with one more point, the original issue that came up after the driver defendant's deposition was that there may not have been ownership, but defendants raised a no evidence MSJ on every element of negligent entrustment, which we believe they didn't have a good faith basis on each of them. So we're further requesting $5,000 in reasonable and necessary.
No, I think there's a good faith basis here.
May I approach, Your Honor? You may want to cross out the fee.
Yeah.
Oh,
I'll cross it. Are you guys, have y'all been to mediation on this already?
Got a mediation schedule with Lexol, first early trial, right, or early June.
One of those.
Yeah, and we've got a trial setting coming up in the next about 30-45 days.
We're trying cases here. You don't assume that it's because it's a 23, you're not going to get reached, so.
Want to get
Yeah. All right, guys, you have a great rest of your day. Good argument, good breaking.
Thank you, Your
of
Honor.
insights. All right, we have a bunch of folks here. You guys here on the Mauricio case? Okay, and what are you, the rest of y'all here for? Wow, you're really early, okay? Okay, well, I can understand that. What about, is everyone here on the Blue Ocean case? No, I'm just asking, so who are you two here for?
We're here on the Crunchy Apps case.
Okay. Are both sides here? It's not time yet. Are both sides here on Mauricio?
Check in with the vendor with that.
Yeah. No, you don't need to check with the vet. I'm sorry, you the defendant or the plaintiff?
Okay.
Bennett, you'll be right over here. And would you guys, Brian, would you mind, there's some paper on this desk. Go ahead and move it. Are you the plaintiff's attorney on the Mauricio case?
Yes, Your Honor.
All right, let's go on the record on it. And everyone's here that needs to be here. Is that correct?
Yes, Your Honor, for the plaintiffs.
All right, let's go on the record on DC 23-20183, Mauricio versus Velez. Council, make your appearances.
Victoria Barboza for the plaintiffs.
We're still representing Bianca Velez.
Right, let's,
Bianca Velez.
And Jared Velez.
all right, let's proceed.
Your Honor, I'm gonna give a brief opening if that's okay with the court.
Sure.
Your Honor, we're here on a temporary injunction. We're asking the court today to restrain the defendants from operating under the business name Immediate Solutions LLC and using the EIN number that was allocated to Immediate Solutions LLC. We believe the evidence is going to show that the defendants have used Immediate Solutions LLC to apply for loans, federal loans, without the knowledge of the other members in the business. The evidence will also show that they opened up an account for those funds to be deposited. The funds deposited were over $200,000. The evidence will also show that my client became aware of it once she received mail correspondence to her address, immediately started an investigation because it could have possibly been identity theft. But then she found out that it was actually applied for and received by the defendants Jared Velez and Bianca Velez. And Your Honor, I'm not sure if the defendants are going to give an opening, but I would like to call my first witness.
You guys are allowed to make a brief opening as well.
We're basically here to ask you to deny the request for the temporary restraining order. We have proof here of actually Oralia transferring over her ownership to Angela Mauricio. So, and actually Angela, company taxes not even being filed for 2019 in Oralia's name because she did transfer over her ownership. So we're here to deny the request for the
But
TRO.
you're saying that,
Asked to the, yes,
so let me make sure I understand what you're saying. So they have a company, it is, sorry,
we had a company, it was Immediate Solutions LLC.
okay, so
That was-
who initially owned the company?
It was Jared Velez and Oralia Mauricio.
You guys owned it, and then you're claiming that, what are you claiming exactly? It was transferred?
It was transferred within, actually on February 7th, 2019, we had a minutes meeting with our CPA.
Okay.
And we had, Oralia wanted it out of her name. And it was then transferred to Angela Mauricio. We have signatures, everything to show that. it was
And who is Angela? What
She's
is
our daughter.
you? Okay,
And in 2019, taxes were filed for the company with Angela. Oralia wasn't even.
how does that impact what's happening now? They're saying that you guys are using the EIN number to
Well,
get
because
loans.
I'm sorry, because they're requesting a temporary restraining order for a company that she transferred ownership to.
She has no ownership.
She has no ownership.
Angela's also a plaintiff.
But Angela's also, okay, but Angela's also a plaintiff.
Yeah, but all over the paperwork, it's Oralia Mauricio that is actually, it's Oralia.
What paperwork are you talking about?
What we were served with, I'm sorry.
Okay. But she's also, but this person is also Angela is also a plaintiff.
Yeah, and we also have proof of why the company actually had split up because of purchases that were being used, and we have those totals as well. And so when that came about, that's whenever,
But have y'all been taking out loans with this EIN number?
What we did was, I'm sorry. What we did was, yes, we didn't take out a loan in 2020. We applied for the PPP loan. And I had applied for it on behalf of the company. And we received it. And then later on that year, I got it, I applied for forgiveness and we got it forgiven, 100% forgiven. And then later, the business, we separated in 2020, January of 2022. We went our separate ways due to mishandling of funds on their end. And so in the year of 2023, I did submit an application for for employee retention credit. But before we paid, when we separated businesses and when I was separated in January, we paid her off and we have in text
But
and
who
email.
owns the business now?
Me and her own it right now. We own it as of September of 23 solely, just us two. And I only did that just because of our previous conversations that we would
What-
pay her remaining money and she would give her rights up to the business. And we have it in text and emails, her
Agreeing
accepting
to.
the money and saying that she's no
Okay,
longer a part of the
that's,
company.
that helps me. So let's go ahead and call your first witness.
Thank you, Your Honor. Your Honor, my first witness would be, Aurelia Mauricio.
Okay. I understand you're a little tight for time, so you got to move quickly.
Yes, understood, Your Honor.
Please raise your right hand. You swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you, Steve. All right, you may proceed.
Thank you, Your Honor. May you please state your name for the record?
Aurelia Mauricio.
And what is your relationship with Immediate Solutions LLC?
I'm a 50% owner.
Okay, and when did you form Immediate Solutions LLC?
When did we
Do you remember
form?
what year?
Yeah, in 2019.
Okay. And who else was a name manager along with you?
Jared Velez,
Okay, and what was the percentage of ownership?
50%.
Okay. And can you please let the court know what was your relationship? What is your relationship with the defendants?
His wife is my granddaughter.
So therefore that makes Mr. Velez.
Mr. Velez, my grandson. Yes, it does.
And did you and Mr. Velez open up any bank accounts for the Immediate Solutions LLC?
Yes, we did.
Okay, and what bank account was opened?
Bank of America, National Bank of America.
Okay. And did you also open up an account for First National Bank? For Immediate Solutions
Yes.
LLC? Okay.
Yes.
And can you please state whenever you found out there was misused funds out of First National Bank, First National Bank?
It's because the CLO, or that man that used to do their taxes and stuff, he told me that they were using the funds to buy a house and they were taking money out of the account that I didn't know nothing about.
And those funds that were in that account, where did those funds come from?
From Immediate Solution.
And were they funds that were received through the SBA PPP loan?
Yes,
And did the SBA authorize you to use that or any? member
no,
to
they
use
didn't.
that?
They said that they got those funds for the company, not for personal use.
And you found out that Mr. Velez and Ms. Velez were using it for personal?
Yes,
And about how much did they withdraw for that personal use?
the first time that we went, that I didn't know nothing about it. I did not know nothing about what they were doing or anything. I was never told. Then, when I started looking at the bank accounts, I saw that $6,000 came out first. And then another $6,000 came out like a couple of weeks later. And then later, I think a month later or so, $15,000 were taken out of that account.
And then more recently, did you find out that after they stated they were going to dissolve the company, did you find out they were still using the company name and the same EIN?
Yes, when we had an agreement that they cannot use that name anymore and we couldn't use that name anymore because she wanted my daughter out of there.
And what did they use the name and the EIN number for?
For personal use too.
Okay, and how did you find out that they were using it? How did you become aware?
The reason I came aware of it, I went into my mailbox and then I saw that there was Immediate Solution letter. So I didn't open it because I never have opened mail. I've always let my daughter open the mail. So when she got home, I told her, open the, I said, we got another thing from Immediate Solution. So she opened it, and when she opened it, it was 200 and something $1,000.
Okay. And with that statement that you received from the bank for Immediate Solutions, the deposit slip was in there, and who did they say the funds were received from?
From, who sent them to them?
Mhm.
Yes, the IRS.
Okay. And when you say your daughter opens your mail, are you speaking of,
Angela Mauricio.
okay. And are you asking the court today to restrain Mr. and Mrs. Velez until this case can be heard at trial and from using the name, from incurring any additional debts, and for applying for any loans that you could possibly be responsible for?
Yes, I am.
Nothing further for this witness, Your Honor.
Any-
I have a few questions. Am I able to question her?
Yeah, so let me explain how this works. You have an opportunity to cross-examine their witnesses. You're each separate parties. They've both been sued, correct?
They're suing the both of us, yes.
Yeah, so each of you can ask questions.
Okay.
All right.
I have a question in reference to, the $15,000. Angela did not receive $15,000
No,
to
she-
build a back house in her. back-
Objection, Your Honor.
No, she didn't. Oh,
Let me just explain how this works. Wait, let me explain how this works. You're allowed to ask her questions. You're not allowed to argue with her.
Got it.
If she objects, then you need to let me rule on the objection.
Okay.
So don't just jump in with an answer. I have a feeling you two want to argue with each
no, I
other.
don't.
This isn't a TV court. This isn't Judge Judy. I'm not gonna allow that. You ask questions, she answers the question. If she objects, then I'll rule on it.
Got
So
it.
let's try that again. You ask your question, you're going to object, and then let me rule on it. So let's try it again.
Okay. Oralia Mauricio, were you aware that funds were also withdrawn from the account by yourself? We have those withdrawals, sir,
Ask questions.
of to allow Angela to build a back house in your back home. Were you aware that those funds that she?
You already asked a question. Are you objecting to that question?
Yes, objection, Your Honor,
And why are you objecting?
because it is a compound question.
Overruled. You can answer the question.
She did open, Angela Mauricio did build a house from in the back, but it was from her money that she had saved from the other job she had.
I also have,
No, you're asking questions.
so when I pull a bank statement of a withdrawal from Oralia Mauricio for $3,000, are you able to provide what you used for that?
I did not pull no $3,000 out.
Okay. Also,
If you have proof of that, you can show it to her and then
Okay.
you can ask her about it.
okay, I have a question. Am I able to?
Yeah, you want to show that? Can you show it to me? Okay, go ahead. Show it right there.
Hold on one second. No, this is not the one that I'm looking for. I want the one where she talks about the $7,200. I'm able to put here some.
Right there. It'll show right up there.
So I do have text messages between Angela and myself, where she is.
Objection, Your Honor. She's questioning Ms. Aurelia.
You need to ask questions. You're gonna have a chance to testify yourself and you can make your argument. If you have a question for her, you can ask her questions. You don't have to ask her questions.
No, I do. I want to ask her here. In the text message here from Angela to myself. I wouldn't take it if I didn't need it. Trust me, but I need the 3, unfortunately. Yes. Mama told me yesterday they had no more money. And when I reference Mamo, Your Honor, that is what we call what we used to call my grandmother, was Mamo. So that's us referencing the money was taken out.
But remember, you're asking a question, stop arguing. So go ahead and answer the question. Was that a text message to you and
No, it wasn't, not to me. I didn't know nothing about it. That is not my message.
Oralia, is this you on, January 17, 2022, going into First Convenience Bank and stating that you wanted to close the account and withdraw $2,577.65?
you got to show it on the screen? Look at the screen up
Oh.
there.
Is that your handwriting, your signature?
Yes, it is. Yes, it is. I did go close the account because y'all had taken all the money already out.
So, we taken all the money out of the account, but yet here it states, correct me if I'm wrong, Oralia, a closing account because we believe someone has access to these who are not authorized on the account.
That's
So
right.
that was false, which you just stated, right? You said that we were closing the account because we had already took all the money out of the account. That's false, correct? Because here you state that you're closing the account because you believe somebody who has information who is not authorized on the account. Is that correct?
That's correct.
So there was money in the account when you
2,000.
went to close it. And am I correct that you went to close it because you thought someone had access to the account and it wasn't because there was no money in the account that was taken out by Jared and I?
It was $2,500, which you called Angela Mauricio, and you were crying because you didn't have no money to pay the employees. So she gave it back to you.
That's false information as well. I have a text message here. Okay. On 4/18/2021, here is a withdrawal slip, Oralia Mauricio, for $3,000. Is that correct? Is that what you see on the screen?
I think that those $3,000, you told me to go get them. I don't remember, I do not remember me getting any money for my personal use to do anything. You know that.
It wasn't for your personal use. That's not what I'm accusing you of, Ms. Mauricio. I'm asking you if you withdrew these funds.
I don't remember.
You don't remember. Is that your signature here, Oralia Mauricio, on the bank statements? We cannot forge that signature, and this is from bank statements that we have pulled in from the account. Is that your signature?
That is my signature.
Thank you. Also, again, on May 7th, 2021, we have another withdrawal from Oralia Mauricio, and that's yourself, correct?
Yes,
Correct, okay, and that was on May 7th, 2021, correct? $3,000. I have also a text message between myself and Angela, actually in May, that I will be able to give you here. That Angela states that she's going to have Oralia Mauricio
Objection.
go
The witness
withdraw.
can't testify as to a text message between Ms. Velez and
You probably want to talk to
I will
Angela.
go ahead and say that, we
You're
have-
asking questions of this witness.
we have any-
If you don't have any more questions, that's okay.
I'm okay for now.
Okay. Do you have any redirect?
yes. Ms. Mauricio, as a manager of Immediate Solutions LLC, are you authorized to do transactions for Immediate Solutions LLC?
yes, I was.
And in those transactions, you're able to deposit, you're able to withdraw funds. Is that correct?
That's correct.
No further questions, Your Honor.
Any other questions for this witness?
No,
You may step down. Call your next witness.
My next witness would be Ms. Angela Mauricio.
Okay, please take a stand. Please raise your right hand. Do you swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth? Please be seated.
Can you please state your name for the record? Angela Mauricio. Okay. And were you an employee at some point of Immediate Solutions LLC?
Yes,
And like Ms. Velez did state in her opening that the company was transferred to you. That is correct?
it was in process of it. From my understanding, our CPA we asked him to do it. It was never filed.
Okay. And when you guys discussed that transfer, did you take, some duties, like as far as?
Well, wait, so let me understand this then. So who actually currently owns the business?
Oralia.
But it was gonna be
Object-
transferred to you?
It was going to be transferred. The CPA was done with us because of Ms.
So your
Velez.
Position now is that Aurelio is the sole owner of the business?
From my understanding, yes.
And can you please state the relationship to the co-plaintiff?
My mother.
Okay. And did you help run the business with your mother?
Yes.
Okay. And did you find out of any misuse of the funds?
Yes.
And did you approach the defendant, Ms. Velez or Mr. Velez, regarding the misuse of the funds?
Yes, some I did.
Okay.
In person and through text.
Okay. And is there a text message that you had with Ms. Velez that stated that she was dissolving the company?
That we were both going to dissolve. That was the last text that I am aware of that we have, that I told her that the plan was for us to dissolve the company.
Okay. So I'm gonna show you what's been previously marked as plaintiff's exhibit 8. Can you please, is this a text message you received from Ms. Velez?
Yes.
And can you state whether you're gray or were you in the darker?
I'm gray and she's the darker
Okay.
color.
So what did Bianca tell you in this text?
There's no way to pay you the 12,000 or even 9 upfront, so the business can dissolve. I will take my clients and move on. I've already talked to them today.
So did you believe after this text message that she was dissolving the company?
Yes.
But did she in fact dissolve the company? What?
Let me ask this, I'm a little confused. So how is she able to dissolve the company if Aurelio owns the company? I'm confused by that.
She was working through her husband as proxy. So,
Who was working through? that?
I'm sorry, Ms. Velez and Mr.
But
Velez.
they didn't own it. According to your client, she just testified the sole owner was Aurelio. How could somebody who wasn't an owner dissolve the company?
So she was not the sole owner. They're 50-50
She
managers.
just testified that
Okay.
Aurelio was the sole owner.
No, she's 50 and 50.
Who's the other 50%?
Mr.
Mr.
Velez.
So he is, and that's currently the case.
Currently, me and her are the owner.
According to y'all, who are the owners currently?
Currently,
You need to understand, when your attorney asks you a question, you need to tell the truth. When I ask you a question, you better tell the truth. And you didn't tell me the truth. You said that Aurelio was the sole owner.
Oh, I misunderstood that part. Yeah, no. It was
Do
50.
you understand how that affects your credibility here? Is when I ask you a question, I'm the one wearing the black robe. You told me something that was not true.
Right.
So everything else you say now is going to be called into question. So when you get a question, you make sure you listen to the question, you answer the question truthfully. Do you understand
Yes,
that?
sir.
That's when I swore you in at the beginning, that's what you were sworn to do. You just told me something that was not true.
I'm sorry, I misunderstood.
But how would
yes.
you misunderstand when I ask you a question that says, who owned the business? You said it was just Aurelia, and now it comes out that it's Mr. Velez as well. Do you understand
Yes.
how that affects your credibility? I can't really believe anything else you say at this. That makes sense?
Yes, sir.
So are you gonna tell the truth from here on out?
Yes.
Okay. If you don't understand a question, you can always say, I don't understand a question.
Okay.
All right, let's go and proceed.
and Ms. Mauricio, so your understanding as far as when the company was first formed, who were the owners of the company?
The owners were 50-50, Oralia Mauricio and Jared Velez.
Okay, and then later there was some discussion of Aurelia transferring her ownership to you, is that correct?
Yes,
But did that ever occur?
Your Honor, there's nothing in the Secretary of State that shows, Angela
My
as,
understanding is that never occurred. You've never been an owner of this business.
Correct.
Is that true?
correct.
And you're
Never
sure that's
been-
true?
From my understanding, yes, sir, when I talked to the CPA last, he never filed it.
So again, as of this time, Mr. Velez and Ms. Mauricio are the sole owners, are the joint owners of this business, correct?
Correct.
So I guess I'm not understanding what you're trying to do. If he's a joint owner, why wouldn't he have the ability to take out loans if he's the joint owner?
because it was done without their knowledge. And they don't know what the requirements of that loan is. Do they pay it back? Will they,
What did the documents?
how the
say?
funds were used?
The documents that form this company, what do they say about the ability to?
There
take
is no
loans?
formation.
All right, do we really want to continue with this, or do you want to?
I have questions.
Well, I'm just trying to,
Your Honor, my client's fear is that she doesn't want to go to jail. She doesn't know what has been done with this EIN number, and she's, elderly, and she doesn't want.
and there's ways to deal with this, and that the company should be dissolved. If that's the concern, but. I mean, you guys created a company, got an EIN number, took out government loans with it. And there are no formation documents. There's nothing that prevents him as a co-owner from taking out these loans. I don't think this is the correct procedure. I mean, but you can go on. I'm just
Yeah.
telling you, I don't think this is the correct procedure. This company needs to be dissolved, that you need to go through the process of doing that. But you admit now that that wasn't what was said before, but he is a co-owner. He has even if he did take out loans, there's nothing that formation documents prevent him from doing that. As a co-owner, he could do it, right?
Yes, Your Honor, I do understand, but I do believe that there's a fiduciary duty that if he's gonna apply for loans that's under a company name that has joint managers, at least make her aware of applying for the loan where the funds are gonna be.
Let me just ask this, guys. Would you in the future, would you agree to an order that said for any loans in the future that are taken out by this company that you will inform her of that?
Actually, there's no reason to do that going forward, Your Honor. We have proof here also that Angela was paid off and said once she paid off her, the one.
So let me just tell you this. What is before me today? I have to decide what is before me today. What is before me today is they're trying to, as I understand it, trying to get a temporary injunction to stop to stop them from taking out any loans.
Taking out any loans, any additional debt until we're able to complete discovery to find
Okay.
out what has been done.
That's what we're here about today. Anything else really is,
And we're here to ask that you deny that.
that's not before me. I guess you're asking me not to do that.
To
Okay.
deny the request
Okay.
because we have also proof here, and I would like to question Angela if I'm able to.
Mhm.
In reference to her stating that Oralia is 50-50 owner of the company. However, in 2019, company taxes were filed by Angela and Jared Velez due to Oralia sending over the transfer to Angela of 50-50 ownership.
What does the Secretary of State's record say on this company? Who are the owners?
As of now, it's Jared Velez and myself.
The Secretary of State's records say that.
Yes, sir.
Let me see that.
Actually, we don't
I
we
don't
don't
have
have
that with
that.
me.
Yes.
Okay, so I'm trying to come up with a reasonable compromise here, which is their
Am I able to
testimony.
question her though in
You
reference?
you can. But if you don't have the records that we have now, what do they say?
The records that we have now,
On who is the owner?
through the Secretary of State or what I am able to present to you as far as conversations being made.
But if she's not the owner, she doesn't have the ability to give away the interest, right?
Correct. But we also have message from Oralia stating, give Angela what she wants. Because she believed at the moment that it was transferred because Oralia has signed her ownership over to Angela.
And Your Honor, I don't want to use too much of the court's time, but we're just asking so that we can complete discovery to see if anything else was taken out and my client no longer be in fear of misuse of any government funds or any loans. And then we'd be more than happy to dissolve that injunction once those discovery documents, and discovery has already been propounded on the defendant.
We also, though, Your Honor, have the loan, the PP, there's no reason for them to fear that. From what I feel is because when we've applied for the PPP loan, it was 100% forgiven.
Okay, let me just tell you that there's a couple options. We can finish this hearing. There is a chance that we would issue an injunction against you, stopping you from taking any loans or taking any actions involving the company. I have to go based on what's in writing, and that not completely, but mostly what's in writing here. You don't have any, you said the Secretary of State says that
I didn't bring it.
Yeah,
I
there-
do have it. I just,
well, then you can bring a future motion on that
Okay.
issue, but what I'm suggesting is testimony seems to be that the co-owners are Mr. Velez and Mr. Aurelia, that you simply, are you planning on taking out any more loans on this company?
that's not what we're doing, Your Honor, but
But look, let me just
No,
answer my
no.
question. So all I'm saying is what I would suggest to give them peace of mind is you agree to, on the record, and we'll do a formal order, that if you do take out any of the loans, that you inform Miss Mauricio before you do that. Can you agree to do that?
Yes, Your Honor.
yes, Your Honor.
Okay. All right. Can you agree to drop your temporary injunction then?
Yes, Your Honor.
All right. So so make it clear on the record, the parties have agreed that Mr. Velez, before he takes out any more, or is it Mr. Velez, I guess?
Yeah.
Before he takes out any more loans on the company, which the name is
Immediate Solutions LLC.
Immediate Solutions, that you will, that this is what the essentially the injunction or the order will say, that he will inform Ms. Mauricio at least 14 days. Is that good before the loan is closed? Is that fair?
Yes, Your Honor. You're saying that 14 days, I will inform them 14 days before applying for one on the loan? Is that
I
what you're
don't know.
saying?
How do you want to do this? Would it be better to applying or closing on the loan?
Applying, it's,
Okay,
that's
how
fine.
14 days before you apply for a loan?
Okay,
Does
that's
that
fine,
work
Your
for
Honor.
you?
That's fine.
All right, so you agreed that you will inform her at least 14 days before applying for a loan. I would suggest strongly here that you guys, this is a mess, this paperwork, and this didn't get done and that didn't get done. There's a lot of blame to go around here, not to doesn't sound like to you, but to the way this was run, that you guys try to reach some type of agreement. Have you been to mediation on this?
no, Your Honor, we are set in, I believe, on June 18th for a scheduling order. I did bring a scheduling order today to see if we can be set for trial, and it's just a uniform scheduling order so that we'll have something.
Have you shown that to them?
No, I have not.
That is something very normal, what she's trying to do. If you guys were attorneys, if you guys can agree to it, then I can sign it today. If you don't, then we need to have a separate hearing. So you guys, why don't you go back in the back conference room? We'll have Mr. Roberts join you. He's gonna be my proxy there to make sure nothing, so if it gets out of control, you can come get hearing, okay? You guys will go in the back conference room and talk about it, see if you can agree to the scheduling order. Why don't you write out this order? Let me just make it clear to you, though, if you violate this order and you take out a loan without telling her, then you could be subject to jail time and to a fine. So I just want you to make sure you understand that. You do need to comply with this order once I sign it, okay?
Yes, sir.
Does that make sense?
And Your Honor, the plaintiffs are asking for an accounting of the bank account that those funds from the IRS were received.
That was not set for today.
Okay. It was in our petition, but we will, can bring it up at a separate time.
All right, so you understand what's gonna happen. You guys are gonna go back there, you're gonna write out a copy of this order. You're gonna see if you can agree to the scheduling order. And if you don't agree to the scheduling order, that's okay. You don't have to, but it is something that's fairly normal.
and that's just gonna be us speaking with their attorney, right? We
Attorney.
do not want to speak to Angela or Oralia.
Let me ask this, how you guys don't get along, I presume, that's my guess?
It was my grandmother and she was my aunt, yes, sir.
Are you gonna be okay meeting with them in this back room, or do we need, should it just be with the attorney?
Just the attorney, I don't want to be around.
Okay, so why don't we do this? Brian and Bill, why don't you go back there? Brian, why don't you go in the room with, or both of you go in the room with them? We'll have, and who is this lady right here, the other lady?
Yes, that's my co-counsel, Your Honor.
Okay, why don't you stay with your clients, you'll sit with them. Brian and Bill will sit with you. If anything gets possible, can get Gary and me, and if it's, don't, that's all, that's your role is make sure everything's okay. All right, are you guys gonna be okay?
Yes, sir.
All right, do you understand? And now if something blows up and you need to talk to me again, you're welcome to come back in here, and I'll talk to you again if there's anything we need to talk
Yes, Your
about.
Honor.
I think you. Does everyone here speak English? Do they all speak English?
Yeah.
Adams v. Smith. I thought we had this all worked out, but I guess it's Adams v. Smith. You guys are here again. Hey, Gary, you go on a break. Let me know. Make sure if anything happens back there that you can close by. Thank you. All right. Let's go on the record on DC 232476 Adams v. Smith. Council, make your appearance.
Johnny Workman and Blake Bailey for defendants.
Sharon Campbell for the plaintiff.
All right, let's proceed.
Your Honor, if you recall, this is a continuation of the motion for summary judgment hearing that we started on May 6th. I believe, and we ran out of time and we were having some technical trouble, so we rescheduled for an in-person hearing today. Sorry, sure.
Ms. Campbell was having a problem with her Zoom.
Yes, Your Honor, that's what was happening. And so we're here today on defendant's motion for summary judgment against all of plaintiff's claims. So when we initially filed this motion for summary judgment, just to remind you, the plaintiff's third amended petition was what was on file. Then Ms. Campbell amended a couple of times, and now what is current is the fifth amended petition. And we believe that we can still proceed on all of plaintiff's claims because all of the substance that is now in the fifth amended petition were also in the third. So while she will tell you that new claims were added, they weren't actually added. Substance was there all along. She just added headers, titles to clean it up, make it more easy to follow in the fifth amended petition. But we believe that we can proceed on those claims because they were already, the substance of them was already in the third amended petition, which is what we filed the motion for.
I think that's where things broke down. Do you agree with that or not?
No, I do not.
What additional claims did you make from?
A promissory estoppel and specific performance. The conversation he's referring to that we had was with regard to the failure to make repairs. That had been discussed, that was in all the, it was written about, but it had not actually been pled. And so I told her, I just put that in there to show that that is part of the claims. It wasn't, I didn't think it came as a surprise, but that was the only cause of action that I was addressing. I don't believe that promissory estoppel and specific performance is covered by the summary judgment. It was not filed until after the summary judgment was on file.
Did you include those two claims in your summary judgment?
I did, Your Honor. Specific performance was sort of addressed. She hadn't pled it in the third amended petition, but we did cover it in our motion for summary judgment because we knew she was asking for possession of the home. She wanted the home itself. So she didn't specifically say that she didn't use the word specific performance, but that's what she was looking for, and that was the understanding. So we actually addressed the promissory estoppel portion of that in paragraph 60 of our
Do
motion.
you have a checklist order for me?
I do, Your Honor. You want me to approach with that?
Sure, that would be great. Thank you so much.
Your Honor, one quick question if I could. I know we had sent over a notebook as you asked for. I don't know if you got it. I've got an
I
extra
did, I'm
copy if
sorry.
you don't.
Can you grab that from Rhonda? I do have that. Thank you so much. Was that in there? I'm sorry.
The order was not,
Okay.
but I brought another copy of the notebook if you didn't get it.
No, I think we do have, I think it's on Rhonda's desk. All right, let's proceed.
Thank you, Your Honor. So, the crux of this case is really, Miss Adams alleging that we failed to repair, the home that she's living in. She's under a lease for this home. The lease expired. We filed an eviction action to evict her, which has already taken place. That hearing was in January of this year. Judge Montgomery, I'm sure you recall, ruled that we were entitled to possession of this property because the lease had expired. That's
And
currently,
Judge Montgomery is the county court of law judge that the JP appeal came from. And because she's the county court of law judge, she has the right to decide issues of possession.
that's correct.
As the district court judge, I do not decide issues of possession unless they're intertwined with issues of title, correct?
That's correct. And that's also one of our arguments for the specific performance part of this is that possession's already been ruled on by the county court judge. And we did include a copy of that final judgment in our, as evidence in our MSJ. So first, Your Honor, Miss Adams' breach of contract claim against plaintiffs. She alleges that we agreed to sell her this property, despite there being a lease and it being a lease situation, not a contract to purchase the home. She alleges that there was a contract to sell her this property for $240,000. There was no written contract, no signed contract. So what she relies on is an oral agreement to sell her this property. However, there was no agreement. There was no oral agreement to sell her this property. We never agreed to sell her the property for $240,000 as she alleges. So the only way to get around that, the statute of frauds issues to assert promissory estoppel, which she's done here, except in order to have a promissory estoppel claim, to get around statute of fraud, she would have to prove that she paid consideration and relied on some kind of promise that we would sell her this property. But there was never an agreement to sell her this property, and she didn't pay any kind of consideration to buy the property. Her argument is that for the promissory estoppel claim is that at some point, which we deny, there was an agreement to sell her this house, and the consideration that she alleges was paid is that all the rent payments that she paid up to this point. She says in her affidavit in the response that her understanding was that we would agree to sell her the property for $240,000, and that all of a sudden, all of the rent payments that she'd been paying turns into a down payment as consideration for purchase of this property, which is false. And also further, the rent payments that she was making can't be consideration for the down payment of the house because the majority of her rent was being paid by the Dallas Housing Authority. If you'll see, I think it's one of our exhibits, A2, I believe, or A3. Let's see. A2 is the Section 8 letter from the Dallas Housing Authority that shows they've been paying the majority of her rent. So she wants to allege that all of this money, all of these rent payments had somehow turned into a down payment as consideration for this promissory estoppel claim. But this is an equitable claim that she's trying to assert, and she can't do that when she's been accepting rental assistance from the Dallas Housing Authority. It's not even her money that she's alleging has been the consideration for this. She has unclean hands unless she's going to admit that she's been defrauding the Dallas Housing Authority by accepting all of these rent payments and then turning them into a down payment to purchase this house. So her promissory estoppel claim can't survive because there is no consideration. And there was no agreement to sell her this property for $240,000 as she alleges. So there's no written contract and there's no oral agreement. So her breach of contract claim and her promissory estoppel claim have to fail. Further, the specific performance claim, which would mean the specific performance claim has to also fail. And in further support of that, the ruling by the county court judge who said we were entitled to possession of this property. in the same case, in the eviction case, she made the argument that she had a contract for purchase of that house. And the county court judge ruled that there was no contract for sale, that it was a lease, that the lease had expired, that we had properly terminated the lease and evicted her, and held that we were entitled to possession of the property. So for breach of contract,
Let me ask a question here. This was not clear to me when Ms. Adams made this argument. So she was arguing that she had title to this property.
she's never had title to the property.
No, that's not what I'm asking. She argued that she had title to the property.
I believe
At
she's,
the county court level,
she argued that she had a contract to purchase the home.
that she had title.
Yes.
Issues of title go to the district court.
I'm sorry.
Issues of title are decided by the district court, correct?
Yes, yes.
Then
But
why was-
she
Why was
couldn't,
why was that decided by the county court of law judge?
because she couldn't produce a contract for the purchase of the house. It was not, she couldn't produce a contract to purchase the house. So it was not an issue because there was no contract.
That wasn't clear to me. That was her argument before, so that's, I'll hear, I guess, from Ms. Campbell about that. All right, go ahead.
Next, Your Honor, the next issue, beyond the breach of contract is the landlord retaliation. She's alleging that, we retaliated against her by filing the eviction action against her. But the Texas Property Code is very clear in section 92.331 and 92.332 that if you're delinquent and if the tenant is delinquent in rent at the time that a notice to vacate is served, then it's non-retaliation. It's very clear about that. And Ms. Adams, if you'll see exhibit, see A3 is the resident ledger that shows that Ms. Adams has been behind in rent since November of 2019. And the eviction action wasn't initiated by defendant until April of 2023. So at that point, she was far behind in rent, which she acknowledges multiple times throughout her petition, the response, and even in her affidavit to the response to our MSJ, she admits that she was behind in rent. So she's barred from saying that this is a retaliation claim because the law clearly says that if you're behind in rent at the time that the notice to vacate and the eviction action is served, it is non-retaliation. So that claim must also fail. Along those same lines, she also says that we failed to make repairs. That's one of her claims, and she's asserted there's no evidence that we failed to make any repairs. And she's under the lease required to make certain repairs on her own, but we don't even need to get to that point because the Texas Property Code is also very clear that if at the time that you make a request for a repair,
Just one second. Gary, can you just, there's nothing bad happening. Can you just go check with them, make sure they come back in here before they leave?
Yeah.
You got up like you were gonna pull a gun. I didn't want you to do that. Don't worry, Gary.
I'll tell you before it.
All right, thank you. I just want to make sure they know to come back in here. Go ahead, sorry.
Sorry, no, it's okay, Your Honor. So along those same lines, the property code is very clear that if at the time you make a repair request, which has to be written under the lease, and under the property code, if you're behind in rent at the time you make that request, the landlord's not required to make those repairs. There is no evidence that she made any kind of request for repairs before she was delinquent in rent. The only evidence that she presents is a letter in January 2023 that requests repairs, but even in that same letter admits that she's behind on rent payments. So her claim for any kind of repairs or failure to make repairs are barred also because she was delinquent, way delinquent in rent at the time that she made any kind of request for repairs. Further, defendants didn't just not make repairs. He heard her requests for repairs. She was delinquent in rent, but he was going to try to make repairs. But here recently, when he's been trying to make repairs, he's been denied entry. So on the one hand, she tries to say that we failed to make all these repairs, that we're neglecting the home. But at the same time, when he goes to the home to try to make repairs and assess the damage, she denies him entry. So we believe that her claim for any kind of failure to make repairs or retaliation, both of them are barred because she was way delinquent in rent, which she admits and acknowledges at the time that those requests were made.
Give me 1 second. So where's the other side?
Meeting with their attorney.
Okay. Go ahead.
Continue, Your Honor. The other claim that we want to address is gross negligence. They assert a claim for gross negligence, but the only legal duty that exists is contractual. It's under the lease and it's statutory. There is no common law duty to make repairs. And so there can't be a claim for gross negligence as well. I mean, there's nothing there that rises to that level. And it's already barred by the statute that says he's not required to make repairs if she's delinquent in rent. That is the duty. And it is under the lease that she's required to make some of those repairs. So we believe that their claim for gross negligence should also fail. Next, Your Honor, is fraudulent inducement. They have a claim for fraudulent inducement, but there is no agreement to sell her the house, and there's no evidence that we ever agreed to sell her the house. There's nothing written, there's no communications, there's no text messages, there's no emails, there's nothing that says we agreed to sell her the house at the price that she alleges we agreed to sell her this house at. So there's no material misrepresentation that was made, certainly not a false one. And there's no evidence that she incurred any kind of damages as a result of relying on that promise. She says that she paid to have certain repairs made, but she's bound to do that under the lease anyway. But she's also not provided any evidence of any expenses that she's incurred allegedly as a result of relying on any kind of promise. So we think the fraudulent inducement claim should fail as well. There's no evidence of that at all. Lastly, Your Honor, there's a claim for attorney's fees and exemplary and punitive damages that she's pled under all of these various causes of action, but we believe that she's not entitled to any of those because all of her other claims fail. As far as our traditional motion for summary judgment on our breach of contract claim, we asserted a breach of contract claim against Ms. Adams for all the back rent that is owed. Breach of contract claim for the back rent that is owed. We did not seek that in the JP or the county court level because it exceeded the jurisdictional amount allowed by the JP court and the county court at law. The limit is $20,000, as you know, and Ms. Adams through today actually owes $55,000 in back rent. And so we're seeking that today. And so we filed a claim for breach of contract. And in support of that, we have a copy of the lease, which is Exhibit A1.
So your claim for breach of contract isn't on this checklist order, right?
It's not in the chart there. No, it's not. It's in that next section on the top of the next page. I didn't break it out in a chart like that.
It's where on the next page?
Page 2 at the top.
Let me see. Oh, I see it. Okay, I misread. All right, that's fine.
I just didn't put it in a pretty chart like the other one. So, Your Honor, in support of our claim for breach of contract, we have a copy of the lease and a copy of the Section 8 notice that shows you what amount she was responsible for and what amount the Dallas Housing Authority was paying. And a copy of the resident ledger, which is A3. So exhibits A1, A2, and A3 are all pertinent to our breach of contract claim for back rent that is owed. And we're not seeking any late fees, just purely back rent. And that amount, when you do the math.
In your motion for summary judgment, what pages are these arguments on?
Let me find it for you, Your Honor.
I see it. I guess it's on page 17. No. I guess page 15.
15,
Okay.
yes, Your Honor.
You have 2 counterclaims, it looks like.
Yes, Your Honor, yes. For breach of contract for all the back rent. And then the next one is due to Miss Adams' fraudulent filing of a lis pendens and I guess what she calls a landlord's breach of contract lien. At the time that both of those were filed, there was no, they were fraudulently filed. She didn't have a claim to title to the property at all at the time those were filed. And so we believe that because she didn't have a claim to title of the real property at all, there was a lease, no contract for sale, that those liens filed were fraudulently filed. And we're entitled to statutory damages for that. And that piece of the argument for the fraudulent liens is on page 17.
Okay. Anything else?
We also had a claim for our attorney's fees, under a breach of contract claim and under the lease permits us to collect our attorney's fees. So we do include that also as an exhibit. Mr. Blake Bailey's affidavit is exhibit E.
Okay. All right, response?
Yes. Your Honor, I tried to make my response kind of parallel of the causes of action that were pled and as they were addressed in the motion for summary judgment. With regard to the breach of contract, I brought up the promissory estoppel agreement to mainly to make the argument that we have recently added that as a cause of action, and that promissory estoppel operates as a defense to or an exception to the statute of frauds, such that it made the breach of contract claim still viable. And I think a lot of these causes of action really are factual disputes. Certainly, Mr. Smith denies that there was any kind of agreement to sell the house. Ms. Adams claims that there was. And we've produced and her testimony is that it was going to be a lease purchase so that the lease the payments from there on out would count towards the down payment, as well as he offered to self finance at first. Then he reneged on that and she got her own financing. But Exhibit 21 to our exhibit is a TREC contract that was prepared. Now, it just seems why would she all of a sudden just come up with this contract if there had never been any kind of discussion about her purchasing of the house? And so it's her testimony that based on the conversations and agreements that she had with Mr. Smith, that there was an agreement to purchase the house. So when she prepared that contract in furtherance of that, that makes out that I disagree with Ms. Workman's characterization of the requirements for promissory estoppel. There's no requirement that consideration be paid. That's not, that's the case law does not say that. The case law says that the partial performance can be a factor, but if there's been substantial action taken, and she has taken, she says in her affidavit that she did make repairs to the property that she was not otherwise required to make, that these repairs that she made were repairs that were the responsibility of the landlord. And she made them because she thought she was going to be the owner of the property. And so she decided to go ahead and make those. That's can count as partial performance. And she acted in relying on that agreement and making those repairs that she was not authorized.
Let me ask a question that I found a little confusing about the petition. It had a claim for gross negligence, but not for negligence. Why is that?
Well, we believe Mr. Smith does have a duty to make repairs on this property. And we believe, and as she states in her affidavit and also in the petition, that the negligence is ongoing, has been for over years.
But in your.
And it rises to such a degree that I think
I've been doing this a long time. You've been doing this a long time. What's unusual to me is that usually people plaintiffs make a claim for negligence and gross negligence, and you made a claim only for gross negligence. And I was wondering why that was.
Well, I probably should have made this, obviously a lot of this was already in place before I came on board, but I probably should have added that in retrospect. But I do think the
Not
facts,
some statutory reason where you
no,
can't recover for negligence, you just didn't complete it.
correct.
Okay.
But we do believe that, and for them to claim that these are repairs that Ms. Adams was responsible for, she states, as we state in the petition, we state in the response, and as stated in her affidavit, a lot of these repairs result from there were 4 catastrophic floods over the period of the time. And if you look at, and to say there's no damages or no repairs have been made, pictures, I attached like 20 pictures of showing what it looks like now. You can see the roof. I mean, it's terrible damage there. And she testifies that really 40% of the property is not even habitable right now, that they can't even use it. And so there's definitely repairs that have not been made. There was one instance where they wanted him to hold off because they were gonna have somebody come check about and do a mold test, and he came and sprayed kills. And which is, I think lay people understand that's not the proper treatment for mold. So there was no prevention of making repairs. And we just believe that the negligence, gross negligence is gonna be recklessness and just disregard. And we believe that is one of the floods actually resulted from a repair that he made to a toilet upstairs that he made himself. And that's part of our argument also, is that he's never had any licensed plumber or any licensed repair person of any kind. And so his self-help kind of repair resulted in another flood. And she paid to have that repaired herself because he would not. And there's never been a permit pulled for any repair that's been done over the entire time that she's occupied the property. The lease does make it his responsibility to make repairs. I don't think it's necessarily contingent upon a written request. And as to the written request issue and the rent issue, we believe the sequence of events show that there was an agreement
Is there
made.
anything in the affidavit that says that she actually requested these repairs be made?
Yes. And it's also, we have as an exhibit, the
So
actual.
let me ask the opposing counsel, is there anything in the agreement that says that the requests to repair have to be in writing?
In the lease does require that the request be in writing.
But exhibit, and it's not disputed that there were times when she was behind, but there was, our argument would be that in the exhibit 23 is a letter that, yes, that Mr. Smith sent about delinquency of the rent, and the letter seemed to invite negotiations about paying the rent back. And she accepted that invitation, and they reached an agreement. And the next 24 shows that she did, and the proof that she made the payments. There was an agreement made to pay $1,000 a month, and she paid that. And so our argument would be that there's been a modification, and that as she's making the terms of that modification, that brings her current in rent for the purpose of making a repair request, what she made around about the same time, which is exhibit 25. And she details specifically repairs that need to be made. And right after that is when the notice to vacate was sent. So that we think that sequence of events, the letter was dated, it has a date on it, but it was January of 22, I believe, 23. And the notice to vacate was sent February 4th. So we believe that sequence of events makes out the retaliation claim, because she was current in rent, she made the repairs, and then immediately after receiving the request for repairs, and she'd also reported it to code inspection, and then she gets the notice to vacate. That fulfills the requirements in the retaliation statute. And as well as there's a DHA notice of failed inspection, which proves that the conditions, and those were conditions that notice was issued, that it's the landlord's responsibility to make those repairs. So we believe that the plaintiff has claims under everything that's been pled, and of course, Mr. Smith is going to deny it, but that's not proper for determination by summary judgment. Now, in addition also to the rent, I would argue that, this is re-argue that that the 40% of the property is not livable, that she shouldn't be required to pay full month's rent. And that's part of a remedy for the failure to make repairs. But, and also I think it's pretty egregious that they are charging treble type rent for their alleged holdover. Also, I would, though I did not represent Ms. Adams at the time of the eviction or in the eviction, the judgment of eviction does not make any finding with regard to any contract for sale or title. Because in an eviction proceeding, that all that can be determined is who has the right to possession at that time. But that doesn't bar any later claim for any entitlement to possession or title to the property, which is what is being claimed in the promissory estoppel and specific performance. So that is not a bar to the claims that are pending here. And I think that I've addressed this.
And what about their claims on their counterclaims?
Oh, the lien, to me, the 91.004 in the property code specifically says that the tenant has a lien for any breach, that they have a lien on property of the landlord. And so it doesn't say anything about filing of a lien, but I think that per se, it doesn't say, I don't think you can take that language of that statute and say that you can't file a lien under that provision. As well as the promissory estoppel, she is asserting an interest in the property. And so that would justify the other lien as well. I don't think it's can be absolutely established that those are wrongful filing liens.
All right, anything else?
I think that's pretty much it.
Gary, can you go get the attorneys out of the back? Do you have any response?
Just briefly, Your Honor, I want to touch on the promissory estoppel claim, first. There's actually a case that both of us, in both the MSJ and the response, oh my goodness. Hold on, I'm going to mess up the name.
Can you spell it? For the court reporter?
Zaragoza, and there's a copy in your binder. It's Zaragoza v. Jensen, and that gives you the requirements for getting around the statute of frauds and a promissory estoppel claim. And it's the case that she relies on as well. And the first requirement is payment of the consideration. It's the very first element. And so I wanted to bring that to the court's attention because that is in fact what it says, that payment of consideration is required. It's the first requirement. And she can't claim that the rent payments, she was trying to allege that she modified the lease to enter into a payment plan. So on one hand, she's trying to argue that this was a lease and that the lease was modified to come up with a payment plan to get current on the back rent. But then also is trying to say that at some point that turned into an agreement to sell the property, but she can't use the back rent and the rent that she's paid and the rent that Dallas Housing Authority has paid as to satisfy this element, payment of consideration. It's just no way. I mean, it would be fraudulent to assert that because Dallas Housing Authority has been paying this to her and on her behalf as rent, not as a down payment or consideration for the purchase of this property. So I wanted to address that first. As far as the liens go, 91.004, I gave you a copy in the binder as well. But it specifically says in the first sentence that the landlord of a tenant who is not in default under the lease fails to comply in any respect with the lease agreement, the landlord is liable to the tenant. The tenant was already in default at this point. She was already in default. There was no claim to title on this property at the time that she filed these liens. And so we stand by that these were fraudulently filed. And you can see even in her form that she tried to file under this 91.004, the lien that she tried to file, which there's a copy of in here as well as an exhibit. it's just a form that she printed off online. She scratched out the title and wrote in landlords. It's not even a proper lien. It's not a proper form, but nonetheless, it's there in the property records encumbering title to this property, which we believe was fraudulently done. Lastly, just to touch on the non-retaliation piece again, even if there was a payment plan agreed to catch her up on rent, the statute doesn't care. It doesn't contemplate that. It doesn't matter whether there was a payment plan to try to catch up on rent or not. At the time that the notice to vacate was sent, she was delinquent in rent, and that's what the statute says. An eviction or lease termination based on the following circumstances, which are valid grounds for eviction or lease termination in any event, does not constitute retaliation. And the first one is the tenant is delinquent in rent when the landlord gives notice to vacate or files an eviction action.
We've covered this before. All right. I'm gonna take this under advisement. I'm gonna make a ruling before the trial setting. You guys have a great rest of your day, okay?
Thank you, Your Honor.
The Mauricio case, you guys coming up? Okay,
Thank you, Judge.
thank you, guys. All right. I need you guys both sides to come up, Ms. Velez. All right, what did you work at? So did you not pick a trial setting? Do you wanna, about when do you wanna be set for trial?
Your Honor, I would ask to be set for trial, I would say 6 to 8 months from now.
Okay, so sometime maybe early next year.
Yes, Your Honor. My clients did request a jury trial.
Okay.
And be set.
Worries. All right, January, let's do, how does January 28th or February 4th look?
Both dates work for me, Your Honor.
February 4th? All right, so this is gonna be set for trial on February 4th, 2025 at 9 AM. And then you have the proposed order for me?
Yes, Your Honor.
Who took it?
All right.
Oh, Gary, can I have the order?
No,
No, the order for the.
Oh, the injunction, Your
Injunction,
Honor.
yeah, did you write that
Oh,
up?
no, Your Honor, I don't have that prepared yet. I
Okay.
will get it to the court.
No, you need to do that right now,
Okay,
so
understood.
go back with them, I thought you guys wrote. So. Go back and do that right now.
Okay.
Get that, you need to sign off on it if you agree to it, then you guys need to come back in, so I wanna get that signed right.
And I'm signing stating that we won't do the, without notifying the court.
14 days before you apply for the loan.
If we were-
That's the whole injunction. It's just that you will notify them 14 days and you agree to that. All right, so go back and write that out.
Yes, Your Honor.
You want to go?
Yes, please. All right, are both sides here on the Blue Ocean Capital case? All right, why don't you guys go ahead and set up? I'll be out in 1 second. You guys can take a rest break. Ready?
We are, Your Honor.
Ready.
Ma'am, what are you here for in the back? At 11:15? Okay. All righty, let me know when y'all are ready.
Ready?
Ready.
All right, let's go on the record, Tony, on DC 243165. Council, make your appearances.
Your Honor, Carrie Panchuk and Matthew Clark for plaintiff Blue Capital.
Morning.
Good morning, Your Honor. Eric Wood on behalf of the defendant 9051 Normandale Apartments LP.
Your Honor, I'm gonna let Mr. Wood go first on his motion to vacate. Just to kind of give you clarification, we had filed an application for the court to confirm an arbitration award that was offered in favor of our client, Blue Ocean Capital. They filed a motion to vacate. We filed a response objecting to it. And so what's before the court is actually our application to conform and their motion to vacate. And so I think probably,
Confirm or conform?
sorry, conform.
Confirm or?
Confirm, sorry, Your Honor.
Okay.
Apologies. And so that's pending. And so I think it's probably most appropriate to have Mr. Wood go first in his motion. I'll respond to it with our objection to his motion to vacate and then request the confirmation. So.
You may proceed.
Thank you, Your Honor, and I agree, there's really two matters before the court, but really, we're not disputing that if you deny our motion to vacate, that you have no choice but to confirm the award. So I of course agree that the motion to vacate should be decided first, and we think it's appropriate in this case. Obviously, Your Honor is I'm sure read the pleadings. I'll try to be brief. This case involves a sale of an apartment complex in Fort Worth. The parties specifically in the agreement agreed to arbitrate all disputes, but they also agreed to limit the arbitrator's powers, which the courts in Texas specifically allow the parties to do. After all, arbitration is an agreement. It's the power the arbitrators get is based on the agreement that the parties have and what the parties agreed to give the arbitrator. In this particular instance, we had an arbitration agreement where the parties agreed to arbitrate all disputes, but they also agreed specifically that the arbitrator could not modify, alter, add to, subtract from any provisions of the contract. And that's key here because that's exactly what the arbitrator did in a number of material respects. And by doing so, the arbitrator exceeded the powers that were granted to her by the parties in the arbitration agreement, which is specifically prohibited and which is exactly the kind of case that mandates vacatur in this particular instance. We understand that arbitration is favored.
During the course of the arbitration proceeding, was this issue ever brought up?
The issue of what the parties' agreement was?
What the scope of the arbitration?
Well, the arbitration agreement was in front of the arbitrator. I don't believe we ever had any specific argument to her as to what her authority was, but the arbitration agreement was certainly part of the demand and certainly offered into evidence. So the arbitrator was well aware of what her authority was per the parties' agreement. Of course, we didn't make these arguments because it was not known that that was going to happen.
Okay,
So-
that's what I was getting at. I thought that might be the case.
Correct. Okay, so what we have here is, again, we have an agreement to sell a apartment complex. Originally, the parties agreed to a purchase price, it was a little over $48 million, and agreed to the closing date at the end of September. The purchaser, which was Blue Ocean, had the option to extend that closing date, which the purchaser did 2 times, well entitled to under the agreement. And then the parties entered into a first amendment of the purchase agreement, moving the closing date once more. But in addition to moving the closing date once more, the First Amendment was important for one material respect. This apartment complex had 408 units at the time the agreement was entered into, and the parties agreed in the original agreement that it was going to have 410 by the time the parties closed. And so there were 2 additional units that were being built out, and that was a material term. It was specifically stated in the original agreement that if that was not done, then the purchaser could terminate the agreement. But the parties thereafter modified that in the First Amendment and stated, no longer can the purchaser terminate the agreement if they're not done. The purchaser has 2 options. The purchaser can either extend the closing date until the units are in a rent-ready condition. That's the language of the agreement the parties signed. Extend the closing date until the units are in a rent-ready condition. That's important, which I'll point on later. Or proceed to close. So that was the First Amendment, which modified the underlying agreement. So underlying agreement says they're not done, purchasing and terminate. They amended that to say no longer can purchase or terminate, but you can extend the closing date. So there ended up being another amendment, moving the closing date once more to January 31.
Do you guys have an agreed order? Can you bring it up to me and I'll sign it? You have the agreed order, somebody?
Yep.
Come on up. You can come on up, I guess. I just need to sign it. Oh, okay. You guys need to agree to this.
Okay.
All parties. And it needs to include in that the new trial setting too, so is it in there? Okay. You guys understand this is a court order. If you're gonna do this, you've got to comply. The penalties are very severe if you don't, that you could go to jail for up to 6 months. There could be a $500 fine. Do you understand that?
I just want to clarify that it is only to inform Horario Mauricio if Jared decides to take a loan out in the name of any.
That's it. And during that time, if you do that, then they may try to stop you, but that'll be for another day.
The business doesn't operate. We've already changed names and we got a whole new.
We have a
business,
whole
a whole new name, so it doesn't even-
And it may not be an issue at all, but hopefully not. Okay. So could go ahead and get them each a copy. You guys go back with him and then the original was. All right, thank you. All right, guys, I'm glad it all worked out. Good luck with everything.
Yep.
And if the case settles, let me know. All right, you may proceed.
All right, thank you, Your Honor. So subsequent to the First Amendment, the parties entered into a Second Amendment, extending the closing date once more and offering and adding that the purchaser will pay some additional purchase money. So now we've got a closing date of January 31, 2023. All other material terms of both the underlying agreement and the First Amendment remained in place. So by January 31, 2023, and all of the earnest money per the Second Amendment was released to my client, which totaled at that point $860,000. Now, under the agreement, paragraph 3.3, the earnest money is non-refundable except in the event of a qualified termination event, which is defined under section 10.2 as a seller default. And that's important, which for reasons we'll get into later. So unless the purchaser can prove a seller default under 10.2, the entire $860,000 in earnest money is non-refundable. So as we come upon the January 31, 2023 closing date, the 2 units are not rent ready. And so on January 30th, the purchaser sends notice. I'm exercising my option to extend the closing date until they are ready. That's the language used in the notice,
Okay.
which mirrored the language in the First
So
Amendment.
what do you believe the arbitrator did that exceeded their authority? What exactly did they do?
Okay, there are 2 material terms that the arbitrator either modified, added to, or amended in terms of the parties' agreement.
Okay.
One was the arbitrator found that the failure to have the 2 units done by January 31 was a material breach. It could not be a material breach anymore after the First Amendment. It would have been a material breach under the underlying agreement because it was required that it be done. But under the First Amendment, it was not a material breach to not have the units done. Under the First Amendment, the only remedy the purchaser had, which the purchaser exercised, was to extend the closing date until they were ready. So the arbitrator found it was breach of a material term to not have them rent ready by January 31. That modified the parties' agreement because the First Amendment, the parties modified stating it's no longer going to be a breach. It's undisputed that the units were done on February the 17th. There was a certificate of occupancy issued by the city on that date, which was provided to the purchaser on that date. Under the language of the agreement that the parties signed, which again stated the closing date shall be extended until the date the units are rent ready. The units were rent ready on February 17th. That was the parties' agreement. The arbitrator further exceeded her authority by finding that the parties never agreed on a new closing date. Well, they did. First Amendment says we agree the closing date shall be the date on which they are rent ready, and it's undisputed they were rent ready on February 17th. The purchaser didn't close on February 17th. My client sent notice on the 23rd saying, you still haven't closed. We'll agree to go to the 28th, but you need to close. The units were rent ready on the 17th. The purchaser still didn't close. As a matter of fact, and we introduced this in evidence, the purchaser sent an email on the 28th saying, we'd like another 60 days and a price decrease. So my client receives that and says they have no intention of closing. The closing date is now 9 days past. So my client sends a notice of termination. And this is the final and most important way that the arbitrator exceeded her authority. And this is the quote, final and official material breach. The arbitrator found that when my clients terminated the agreement on the 28th of February without having a closing date, that materially breached the agreement, which forgave the purchaser for ever having to do anything because we didn't give 3 days notice. Well, paragraph 10 of the agreement specifically states that if the purchaser does not close on the closing date, my client doesn't have to give 3 days notice. They can terminate right away. That's exactly what happened here. Purchaser does not close on the 17th or any other date thereafter to the 28th. Therefore, my client provided notice of termination without any requirement to give 3-day notice. It says right here, except no notice or cure period shall apply if purchaser fails to timely consummate the purchase of the property. That's what happened here. The purchaser never consummated the sale of the property on the closing date. My client terminated and was entitled to keep the earnest money. The arbitrator found that my client should have given 3-day notice. That violates this provision of the contract that says no 3-day notice is required. And as a result, the arbitrator found that the purchaser was entitled to all $860,000 back under paragraph 10. That modified materially the parties' agreement, that modified materially part of the First Amendment, and therefore the arbitrator exceeded her powers. And the earnest money should have and had to remain with my client because there could have been no breach by my client. The breach was by the purchaser for failing to close. And I'm happy to.
Response? Thank you so much.
May you please support, Your Honor?
Just address the 2 issues that he's addressing. I don't need to go through a lot of history. There is a huge presumption, I understand, in favor of arbitration. So I really want you, and I understand that. I'm not a huge fan of arbitration. I don't like the huge presumption. I've spoken on that topic. but I've learned that the Court of Appeals, and especially the Supreme Court, recognizes the strong presumption in favor of arbitration. So I understand
Understood.
that.
I will,
But all I want you to really touch on is those 2 points.
sure. Couple of his points were that the arbitrator amended an agreement to close on February 17th. There was no new agreed upon closing date, Your Honor, after January 31st, 2023. It was a condition precedent before that official closing date. In 6.4, section 6.4 of the PSA, they had to have 410 units. They reached that date and did not have the units ready, which forced my client to then say, okay, we'll go get them ready. They finished them on February 17th. They give my client, after some notice on February 23rd, 3 business days and propose a date to close. My client said, we have other issues you need to address. And instead of addressing those issues, on February 28th, they sent a termination notice. And essentially what the arbitrator found, which is well within her scope of authority to look at the rights and the obligations of the parties under the contract, was that they failed to consummate the transaction in February 2023, because essentially they wait 9 months, don't have the units ready. And by the way, you don't have the record of this, but every other extension that was granted on a closing date complied with section 12.6 of the contract, which said any amendments need to be agreed to and in writing. This court doesn't have the record, you don't have the testimony, and you certainly don't have all of those communications because they don't want you to see them, in which the prior extensions were all agreed to
I
in
think you
writing.
made an argument that I can't vacate without the entire record. Wasn't that part of your argument?
That is correct, Your Honor.
So to actually talk about that.
Sure. The entire record, what you would see in the record is, one, you would see a timeline of,
First address the issue of the fact your argument seemed to be in the briefing was that I could not vacate if I didn't have the record.
sure.
Okay. So address that issue.
That particular issue, Your Honor, is essentially you would not have the evidence that would actually let you see what the arbitrator evaluated. She had the scope of authority, and the case law is strong. The inference is that if her authority is to interpret the rights and obligations of the parties, and you don't have access to the full record and testimony and evidence in which
He is the trial judge.
yes, then on any type of review, you can't make those determinations. They have to be made in favor of the arbitrator who had the full testimony, the full record, all the emails, and all the communications related to this particular transaction. Otherwise, you end up in a situation where they're making factual disputes, or they're trying to relitigate the issue by selecting what particular details they want to focus on and leaving out details that show the full record of what happened between these parties. I will also address, he argued that the arbitrator went outside the scope of her arbitration by finding that it was a breach of a condition precedent to not have the units ready by January 31st. There's actually a provision in the contract that says they have to have them ready by closing. But that breach wasn't even the breach that justified the award. The main breach was the fact that they just terminated the agreement without notice while our client was still trying to close. And that was ultimately the award on the breach of contract. The condition precedent he's arguing about related to the fraudulent inducement behavior, in which over a period of 9 months, they never completed the 2 apartment units, but continued to collect earnest money from our client, didn't have them done by the official closing date. Then they reach February and all of a sudden say, okay, they're ready, let's close. We don't have a new agreed closing date in writing, and then they just breach the contract and terminate and try to keep their earnest money. Excuse me, Your Honor. So without the full record, it would be impossible for any appellate review court or any court to look at all of the factual evidence to determine how the arbitrator ultimately found the rights of the parties based on their performance over a 9-month period and based on the timeline of those particular communications.
Okay. Address the issue of how I can decide this without the record.
Absolutely, Your Honor. And we cited the case law in this brief. There is not an absolute requirement that you have to hold the record or therefore you can't rule. What the case law says, and this is the Dallas Court of Appeals, is that you are not entirely foreclosed from considering the issue It just limits you to determination of the issue based on the record that's in front of you. I haven't heard any actual evidence that's missing that would make a difference here. We agree that all agreements between the parties, including modifications, had to be in writing. We had a writing here as to what the closing date was going to be. This manufactured position that the purchaser takes in their briefing here and took at the arbitration was that, well, I never agreed to a new closing date. Well, I don't dispute that he said that. It doesn't matter what he said though, because again, the party's agreement was that all agreements and modifications had to be in writing. And the agreement in writing here was that the closing date would be extended until the date the units were rent ready. That's what the parties agreed. So there was an agreement between the parties. The only agreement between the parties as to the closing date was the First Amendment. And that said, the closing date will be extended until they're rent ready. Otherwise, the purchaser could just say, I'm not ready. I'm going to close whenever, which is essentially what he did here. He tried to get more time, more time. Well, the parties did agree. If there's no documentation introduced in evidence that says the parties had to come to some other agreement because they had an agreement. And even the notice that was provided by the purchaser on January 30th cited that very language, says we only want to agree to extend the closing until they're rent ready. They were rent ready on the 17th. 9 days go by and the purchaser still isn't closing. He's telling them, I want another 60 days. I want it to decrease the purchase price. My clients were well aware at that point the purchaser breached his obligation to close timely, and therefore they were within their right to terminate the agreement. That's the evidence that's in the record. There's no other evidence that you need to make a determination whether the arbitrator exceeded her powers in this particular instance. And I haven't heard of any missing evidence that you need. All of the agreements, all of the pertinent communications are before the court. You can determine as to what the parties agreed to the closing date. You can determine based on the undisputed evidence as to when the units were done and when that closing date was. And you can determine based on the undisputed evidence that the purchaser never was able to close within even almost 2 weeks after that date, which gave my client the right under the agreement to terminate and retain the earnest money. Thank you.
All right, guys, I'm going to take this under advisement. We'll get you a decision as soon as possible, okay? You guys have a great rest of your day.
Thank you, Your Honor.
Thank you, Your Honor.
We excused?
You are.
All right.
All right, Yacho versus Roche Construction, I think is the name.
Morning, Your Honor.
Morning,
Steve, sir.
morning.
Tom Farmer for Rushco Construction.
So the defendants are on this side, plaintiffs are on this side. And ma'am, I thought you were here on this case too. You can come up. Okay, I thought you were here for this hearing. Okay. All righty. All right, so the main reason I wanted a hearing on this is this case has gotten very old. It's 21K. You guys moved for continuance again. You know, we're getting a lot of pressure from the legislature about and the Office of Court Administration about even granting continuances. This case is, what is it, 2.5, 3 years old. And so I'm just being very hesitant to grant continuances of cases this age. They're doing what they're doing in federal court where they're tracking our cases. You know, they 0 to 3 years old, 3 months old, 3 months to 6 months, 6 to 12, 12 to 18, I think 18 to 24. I mean, this case is old, and so in the summary judgment, it just didn't appear, or the continuance, it just didn't, I wasn't really clear why we're here at this point, why this case can't go to trial.
Rob Crane for the plaintiffs. Very much appreciate that perspective, Your Honor, and we appreciate this court always moving its docket quickly. And the law firms involved here, I think we've got a fairly good track record of moving cases along. Two things are at play here that are somewhat outside the court's necessary concern, one of which involves the legislature, and that is certificates of merit. This is a lawsuit that involves a gentleman on a bicycle path up in Plano that had been recently connected. It's the Legacy Trail. Pacheco Coat, the defendant, designed the drawings for this bike path construction and connection. Roshco then constructed it. negligence claims against both entities. There's not any premises liability claims against these two entities because they did not own or control the path. You're gonna hear about that next week. So Mr. Fiacco comes around a curve and his front tire, as expert testimony will elicit, dips into a crack that is between the path, bike path, and a bunch of large boulders, which shouldn't have been there. So the plaintiff's allegations in this case are, the original drawing said grass was supposed to be planted in this area, but it was underneath an overpass. And the builder said, hey, we're not gonna warrant this grass because it's not gonna grow in the shade. So ultimately, a decision's made by Jayco Coke. We'll put riprap there, big, large stone boulders, new term for me. What Jayco Coke did not do was amend their drawings to give specificity as to, well, how do you put big boulders to the side of a bike trail when bike trail standards require a minimum 2-foot flat shoulder on the side of the path, and the deviation between the path and whatever's next to it, be it grass or small rocks, can't be more than a ½ inch. Two standards that were required in the contracts for both of these defendants. Mr. Fiacco's bike front tire dips into that crack that's there after coming through a series of S-curves and from sunshine into shade, and he does a flip, lands on his head, snaps his spinal cord, severs it. I've never seen a scan like this. He cannot feel anything from the chest down. So when we brought suit, initially we looked hard at this, we realized, well, we're suing an engineering firm, requires a certificate of merit. The engineering firm had a landscape architect make these decisions about what was to be put here adjacent to the sod. So we sued him individually. Well, that requires another certificate of merit. So that postponed the filing date to 2021. When we get initial discovery, we realized, wait a minute, there's potentially another engineering firm here, IEA. And there's these emails that get confusing. They talk about riprap, and it's unclear as to whether they're talking about riprap with this potential new defendant, IEA, in regards to the riprap beneath some unrelated area, or if they're talking about riprap underneath this overpass where this accident happened. So we had to send depositions on written questions to the Jayco Coke to get clarity on, well, what do these emails mean? Well, we're told they mean, oh, it's the stone under this overpass where this accident happened. So we got to do another certificate of merit. So we do that, and then we file suit, and then the counsel that answered for IEA steps out, Thompson Co. steps in, but they don't step in until the beginning of 2023. So we're really not starting this case in earnest for full discovery until 2023.
Who's here for that?
IEA is now settled out with King Pfeiffer's mediation that you ordered recently.
Okay.
The second thing that the court may find relevant or not, but it is certainly relevant to plaintiffs. And we didn't put this in the motion, and rightfully so, as counsel didn't necessarily want it.
Well, is this something private? Because this is on YouTube right now, so.
I think we're okay with this. They've got an insurance policy that's a wasting policy. I won't say the amount, but it's a wasting policy. And certainly with these kinds of damages, we don't feel like that policy is sufficient. So we're very mindful that obviously attorney's fees, expenses that are incurred in the defense of the Jayco Coke come out of this policy. So we've been mindful step by step that we try to do this as efficiently as possible. So it's been a slow moving process in large part because of the legislature's requirements on certificates of merit. And we've been a little bit.
But those were all done back in 2021, right?
Well, not the one for IEA.
Okay, that one was delayed, all right.
And they didn't answer in full earnest with their counsel go forward until the beginning of 2023. Yesterday, we sent over all the expert reports. We've got MSJ hearing with you a week from today. There's one other significant legal issue you're going to hear on our motion to strike. City of Plano is a responsible third party because they don't have, under the recreational use statute, we don't believe they should be anywhere in this case, even as an RTP. You'll hear about that later. So we've got everything now done from the plaintiff side. We've got the legal issues teed up. The parties have now agreed on a September 17th. Right. I don't think you're right. I used to work in this, September, no, he's right. September 17th. So a September 17th trial date. So we put this on a fast track with where we are, which we believe to accommodate, we're hearing from you. And so that's where we're at. We're good to go on the 17th if the court will oblige us.
Did you talk to Rhonda about that date, or did you just come up with it on your
We
own?
called the court before we put the proposed schedule together.
But Your Honor, if I may, I think that was 3-4 weeks ago. Right, this, the joint motion was filed. I'm gonna guess about a month ago.
You just look at that date. Okay, yeah, you would be at the moment, you would be number one that week. How long is this gonna take to try?
Less than 2 weeks. Depends on when we
The,
start.
the concern I have about that date is I believe, let me look it up. I think bench bar might be the next week. No, it's that, sorry, you're asking for September 17th. It's that week. No, I have it down twice on my calendar. It must have moved. Do you know when bench bar is?
I'm looking on my calendar. It should be there as well. Do you recall, are they leaving it here in town?
It's at Rockwall. I don't know if they put it on the website, but I got an email about it. Oh, let me get that. It's September 19th and 20th. So I typically go to that. I don't know if you guys go to, I know Mr. Crane usually goes to it. It's local, so we would probably need to take that Thursday and Friday off from trial. I don't know if that's something you guys want to do. We would start Tuesday, go Wednesday, and you guys could go to the next week. I don't know if that's the ideal way to do it. You might want to bump it back a week, potentially.
Mr. Ewing, he had asked us to push it earlier to that 17th date because are you familiar with your partner schedule?
I know he's going to Greece in October, Your Honor, but Mr. Ewing, who's my team leader, we tried the case together. It had various communications with Mr. Crane that I wasn't in on, or sometimes I get behind on a couple hundred emails a day.
I mean, would the 24th work for you guys, or do you want to check? Sorry,
I'm okay with your proposed schedule of getting started that week of the 17th. And
then just going 2 days that week and then going to the next week. I mean, it doesn't seem like
I'm good either way, as long as Mr. Ewing is okay. It seemed like he had some question as to when he was going to be leaving. At least he knows.
I will say the week of the 24th, you would not be number one. There is a case ahead of you. I don't know the status of that case. I can't, this is a really old case. How did this case get so old?
And I'd prefer we leave it on 17th.
Let me just see if the case is still active. It was remanded to us from the federal court or from bankruptcy. Let me see. that case may be in federal court, let me see. Okay, it was remanded back on. All right, so it was remanded from bankruptcy court back to our court, which is why it's so old. So that case could go, or we could go a week, potentially a week earlier, maybe. Let me see if I have that might be the best way to do it. You'd be number one on September 10th and see it's September 3rd.
That's good for us.
I agree with Mr. Crainer on it.
Let me just check September 3rd. And you, yeah, definitely be number one on September 3rd. So either of those, the 10th or the 3rd works. That might,
Labor Day is the 3rd.
this is my thought though. If you start on the 10th and it's really 2 weeks, then you're gonna have that issue the second week of trial. So maybe the 3rd would be better. I know you don't want to get with Labor Day, but how long is this really gonna take? I mean, I don't know.
I'm confident that if we started that second week,
You start, you
we'll be able to get it done.
get it done. Like how many trial days are we looking at?
We're starting on the 3rd.
The 3rd, you'd be fine. On the 10th, could you finish it in 6 days of trial?
Yeah, I believe we can.
What if,
Go ahead. I'm sorry, 6 days, Rob?
Well, it's really 7 because the bench bar is the 19th and 20th.
Right, but we don't have trial on Monday. We have hearings on them.
Your Honor, there's gonna be at least 10 experts live, 10, and that's experts only, not counting fact witnesses. I don't see us getting this thing done less than 2 weeks of trial.
Maybe, I know it doesn't sound like you want to give up your Labor Day weekend, but that may be the best way to do it.
Okay, we'll do it.
Is that what y'all want?
Are we saying the 3rd, starting the 3rd or the 10th, Judge?
3rd, I'm just trying to avoid the issue of you going, having a big break, so. I mean, it's up to y'all. But if you start on the 3rd, you're gonna be clear. If you start on the 10th, then you'd have 4 days that week, and then the next week you'd have 2 days. And you seem to think, no, I'm not fussing with you, but you seem to think that that wouldn't be enough time, and you may have to go into a 3rd week.
I think that'd be difficult, Judge, all those breaks. I'd rather start the 3rd. And you said we're number one if we're on the 3rd?
Yeah, the 3rd or the 10th.
Because I know some of the experts will be coming in from out of town, so if that's almost like a special setting, that may be the best for us.
I could specially set you if you want, but you'd need to verify that that's good for the experts. Right now, you're by far the oldest case that week at the moment, but if you wanted to request a special setting, I'd want you to get confirmation that it's good for all your parties. Are we all good for the 3rd?
3rd works for the plaintiff's, Your Honor.
yes, sir.
Yes, Your Honor.
All right, Rhonda, are you there?
Yes, Judge, I'm here.
Go ahead and reset this case. This is the Fiacco. Is that how you say it? Fiacco versus Rushico case.
Okay.
And Pacheco Coke.
Yeah, and Pacheco Coke, for September 3rd. And if the case settles in the interim, please let us know. And if you do decide you want a special setting, just request it with the court.
You know, we had prepared a scheduling order for you, but now that we've got a different date, can you go back and then submit the proper?
If you want to just interline it, you can, or if you want to submit a new one, you can as well.
Let us take a minute to review it. We'll resubmit with the trial date.
Okay. All righty, guys, you have a great weekend, and we will see you soon.
Thank you, Your Honor. Good to see you.
And we be excused, Your Honor.
Hey.